right to the Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in matter of Standard Construction Company, Inc. versus State of Arizona et al. Our civil number 19-0411. Each side will have 20 minutes within which to present their argument here this morning. Appellant may reserve some portion of that for rebuttal. However, it's up to you to keep track of your time in that regard. We have reviewed the briefs. We've been through the record. We have conferenced the case. So we're familiar with the underlying facts and the issues that you've brought before us here today. So please keep that in mind as you make your arguments. With that, appellant may proceed.
Thank you. May it please the court. My name is John Egbert. I represent the plaintiff appellant, Standard Construction. This appeal at its heart is a statutory construction case. The statute here, subsection C of section 12-82101, provides for deferred accrual of the statute of limitations in certain kinds of cases. Our position is that the trial court erred in 3 different ways, any one of which is sufficient to reverse the dismissal of Standard Construction's claims. If you look at the statute, subsection C, and it's quoted in full on page 11 of the opening brief, but it's clear that there are 2 sections in subsection C. One, the first part of it deals with what claims qualify for the deferred accrual. And then the second part addresses if the claim qualifies for the deferred accrual, then how long does that deferral last? When does the statute of limitations kick in again? 2 of our arguments of the errors of the trial court address the first part about what qualifies. Our third addresses the second, which is how long does it last, assuming that our claim fits within it. Let me address the first half first with the 2 arguments. The first one is that while the contract here says that the contractor here, Standard Construction, may request mediation, that doesn't necessarily mean that the request is permissive. And there is a line of cases, and in fact, one of those cases says Arizona case law solidly supports the notion that just because an administrative procedure, or in this case, a contractual procedure process says that it may request, doesn't mean that it means anything other than you may, but if you don't, you're going to lose your right to pursue litigation further. So at a minimum, our position is that the court ignored that case law and erroneously concluded that the request for mediation did not qualify as a binding or non-binding dispute resolution process, which is one of the ways you qualify for the deferred accrual. At a minimum, if that isn't the court were to conclude that isn't the law in this particular case, construes the contract to not mean that, then there's at least an ambiguity. There was an ambiguity in the mind of counsel for Standard Construction, and that at a minimum we submit would be a proper basis for relief under equitable tolling. The second argument of error that we rely on.
You don't need equitable tolling, though, to make your case, right?
I'm sorry?
Equitable tolling isn't really necessary to your argument, though, is it?
No, it isn't, Your Honor. Okay. And our position is that the both the contract and the statute itself can be construed in a way that is consistent with our claim, being appropriately the accrual deferred. And so the equitable tolling is simply our backup, our worst
What's
case
the
scenario.
argument for construing it in another way? I mean, in other words, if the contract is ambiguous, we would construe it. I'm trying to decide first whether it is ambiguous.
So our position, one ambiguity would be that the use of the word may, when competent counsel goes out and looks at case law and says, okay, I've got a procedure here that I need to follow before I can go file my suit, and I've got case law that says that may doesn't necessarily mean that it's permissive. It may absolutely be a prerequisite required before you get to go to court. And if you don't get to go to court. So that's one area in terms of a possible ambiguity in the contract. But there's a possible
But isn't may? I mean, may is not an ambiguous term, right? May is the quintessential permissive word, and so we know that the decision to elect alternative dispute resolution is permissive, right? There's no real way to argue that anything else.
Your Honor,
I'm not saying that if you concede that point, that automatically concedes the rest of the case. I'm just taking it in baby steps.
I hear what you're saying, but I guess I'm not willing to concede even that much in light of the case law, because again, the Molyneux decision at 207 Arizona 1, that's a case where this court said Arizona case law solidly supports, and I'm taking out some language here, the notion that, quote, the presence of the word may in an administrative procedure does not necessarily render the procedure permissive. So on its face may look unambiguous.
But you couldn't argue, for example, that may required your client to demand ADR.
No, but we could say that it required them to demand ADR if they wanted to pursue it further past the decision of the state engineer.
So you think if your client had not demanded ADR and just filed a notice of claim, that it would have been in breach of the contractual requirements?
Not in breach, Your Honor. It's permissive in the sense that you don't have to bring a lawsuit, but if you want to, you have to comply with all of these steps.
But if you want, so you would read it to say that if you want to bring a lawsuit, you must demand ADR.
I would say two things. That it's possible to read it that way, yes. And number two, even if the court is uncomfortable reaching that conclusion as a matter of law, that's how you're going to construe the contract. At a minimum, I think it becomes...
It would just seem bizarre to read it that way. I mean, why would the drafters write may if they meant must?
Well, there are a number of cases where there have been rules and regulations and statutes that use that word may, and courts have interpreted it as meaning
I understand
required.
that, but all those cases arose in their own factual contexts with their own contractual ambiguities, and I'm not terribly interested in what judges have said about other contracts. I'm interested in reading this one.
Understood.
This is your case, and I don't see any way to read may as mandatory with regard to your client's decision to demand ADR. You could still argue, even if that's permissive, that the ADR itself becomes mandatory. I understand that.
And that is indeed my second argument, that the judge was wrong because the judge even said that it is mandatory once standard construction elects to do it, that the state had no choice but to pursue the mediation.
And that puts it squarely within the provisions of subsection C.
Yes, because then it becomes a claim that must be submitted, and that's all that it says. It doesn't say it must be, that it's mandatory as to all the parties. It just says that it is a claim that must be submitted to a binding or non-binding dispute resolution process, administrative process, or review process. That clearly is the case here. By the judge's own finding, that this was a case that once standard construction said, we're electing this, that the state had no option but to submit it. It must be submitted, and that therefore complies with the first part of subsection C. So that's point number 2. Our third and final point now shifts to the last part of the subsection C, and that is an argument where if the claim must be submitted for any reason, even if it's not the mediation reason. So here, the trial court judge said exactly that. This is clearly an issue that must be submitted to an administrative process as set forth in subsection C. So the other portions, even the state, even the defendants agree that standard construction was obligated to submit it to this administrative process. So there's no question the first part's satisfied. Then the question only becomes, if that's true, and it is, then how long was the accrual deferred? Their position is that it only was deferred through the time of the mandatory process, and they say that the mediation wasn't mandatory, and therefore it didn't continue to be deferred through the mediation. The problem with that interpretation is that it writes out critical language from subsection C, and let me explain that. In the first part, the eligibility for the deferral says that it must be submitted, it's a claim that must be submitted to a either non-binding or binding dispute resolution process, administrative claims process, or review process. But it only has to be have to be submitted to a process. And then in the second part, it says that it will be deferred until all such procedures, processes, or remedies have been exhausted. So the first part only talks about a, and then it lists kinds of processes. And then the second part says it's deferred until all such, not only processes, but procedures and remedies. The first part doesn't talk about procedures or remedies. It talks about dispute resolution processes, administrative claims processes, or review processes. Then it defers until all procedures, processes, and remedies. So in essence, the defendants are writing out from subsection C the terms procedures and remedies. It's clear here that if you have a claim that must be submitted to a process, it's undisputed by everyone, including the trial court judge, that that's the case here. Then the accrual is deferred until all procedures, processes, and remedies have been exhausted. The mediation provision is part of the administrative process. So in essence, it becomes irrelevant whether or not it was mandatory, because it now it's part of the procedures, processes, and remedies that are part of that contractual provision. And we submit that the combination of either the mediation being mandatory, at least as to the defendants having to submit it to mediation, or even if it's not, because it's part of the procedures or remedies that they would completely write out of the statute, either way the judge was wrong in dismissing on this basis. And I guess we would say that if there's an ambiguity in that decision-making, then that ambiguity for a number of reasons has to be construed in favor of standard construction, not the least of which is that it's their contract and it should be construed against the drafter. And again, I'm now talking about when you have an ambiguity, then you resort to the secondary level of statutory construction principles. One of them is that principle, it should be construed against the drafter. Another very important one is the legislature itself as quoted by the Supreme Court in the Pritchard decision, said, "It is hereby declared to be the public policy of this state that public entities are liable for acts and omissions of employees in accordance with the statutes and common law of this state. All the provisions of this act should be construed with a view to carry out the above legislative purpose."
Counsel, let me ask you about counsel's admission. According to the state, plaintiff's counsel admitted that the claim accrued before mediation. Your position is that that's irrelevant, essentially? And so one of the points you make is that if that email is considered at all, it should be viewed in the light most favorable to your clients. Tell us how that should be construed.
So, Your Honor, if we're going to consider at all, and that's our first position, that it shouldn't be, but our second position is just what you said, it should be viewed in light most favorable to the non-moving party here, and that same email, right after it talks about, well, when does accrual happen, specifically says that we do want to pursue mediation, and talks about that's what we're going to do. That's the next step. So even if counsel believed that if I didn't do anything, the accrual's going to, the clock's going to start ticking on me now, but I am going to ask for mediation. And because I'm asking for mediation, then that under the deferred accrual of subsection C should defer the start of the statute of limitations even further. So that would be a way to construe it that would be more favorable to us.
So your position is that it was implied in the email that there would be, that the time would be told?
Yeah, a reasonable inference would be that, look, we are now going to request mediation. I hereby do that. And therefore, the accrual, we should get the benefit of the accrual. And look, even if the counsel was wrong, it's not a binding judicial admission. It wasn't even a judicial admission. And so and we cite some case law in our brief. I would like to save a few minutes for rebuttal if I could.
Thank you, counsel.
Good morning, Your Honors. My name is Aaron Shepler. I'm with the Glendale City Attorney's Office. I'm here today on behalf of the City of Glendale. With me today is one of my co-counsels, Kurt Christensen, and also in the gallery today is ADOT's counsel, Joe Acosta. I'd like to start off by saying that I disagree with Mr. Egbert on one key point. This case is not about statutory construction. It's about construing the contract. Because ARS 12-821-01C says, and I'm paraphrasing a little bit, if a party is contractually required to submit its claim to a dispute resolution process, its claim accrues when that process has been exhausted. So the question...
You're paraphrasing.
I'm paraphrasing a bit.
If we're going to construe provisions you consider ambiguous, why don't we quote instead of paraphrase?
I don't consider the statute to be ambiguous at all.
Well, the way you read it, though, renders it ambiguous, because what the statute actually says is a claim that must be submitted to a binding or non-binding dispute resolution process. It doesn't say a claim that's required generically to be submitted, but as I read it, once standard demanded mediation, you didn't have a choice. The claim must, at that point, be submitted to mediation.
That's true. But in talking about 12-821-01C, the question is, what is the process to which the claim must be submitted? And the statute, of course, talks about a number of potential sources out of which that duty to submit to...
Well, doesn't the contract say mediation, which is a non-binding dispute resolution process?
It does, but it also starts, if we start at the beginning of the contract, it says that there's a 3-step administrative process, 3 steps. Review by the resident engineer, semicolon, review by the district engineer, semicolon, review by the state engineer, period.
And those
There is no
happened.
step 4.
Those happened, right?
Those did.
Okay.
And at the conclusion of that process, Your Honor, the deputy state engineer, Mr. Gutierrez, issued a final decision.
But I guess what I'm not grasping yet is if the state was required to participate in mediation at the request of Standard, why is that not one of the remedies that must be exhausted?
Well, there's a couple of answers to that. One is that the contract itself says that it's a 3-step administrative process that concludes, that culminates with the final decision of the state engineer.
As a practical matter, then, you're saying if the administrative process, as you define it, it concludes and a party elects ADR, they're effectively, for all practical purposes, forfeiting their right to sue.
Not at all. What they could have done, Your Honor, what Standard could have done in this case but did not, is I should say that the contract doesn't prohibit it, first of all. And that's really the key, because the statute talks about the various sources of law or contract out of which a duty to submit to an ADR process may arise. It includes statutes, ordinances, resolutions, and contractual terms. So in any case in which subsection C is implicated, what we first need to do is find out what is the process to which the claim must be submitted. What is that administrative process? When does it begin? When does it end? And when does the claim accrue? And the contract in this case spells it out for us very nicely. The contractual provision, of course, that I'm talking about is 105.21. And it says the administrative process for the resolution of disputes is sequential in nature and is composed of the following steps. And as I mentioned, it's review by 3 engineers, period. That's the end of the process.
So counsel, just so I understand this, in your world, the concept of mediation, even though it's provided for in this contract, is not part of an administrative process?
It is not as set forth in the contract.
Well, if we define administrative process as that process that must be completed, if applicable, before litigation is instituted, clearly mediation would be part of the administrative process, wouldn't it?
Not under this contract. For purposes
So you think this mediation provision is just something floating out there in the ethereal world?
No, but what it does under the contract, Your Honor, it actually post-dates the accrual of the right to sue by the contractor. And how do we know that? Because subsection D says, if you don't like the state engineer's decision, you have 2 options. And really, it's just one option. But if the amount in controversy is less than $200,000, your option is go submit it to arbitration. If it's greater than $200,000, it says the contractor's sole remedy shall be to initiate litigation pursuant to section 12-821 at sec of the Arizona Revised
Your
Statutes.
interpretation is that this concept of mediation is simply a process that follows the institution of litigation as opposed to preceding it.
No, because the mediation provision, what it says is, okay, your right to sue has accrued because the state engineer has issued his final decision. What the contract says is, now if you want to, this option is available to you. You can ask for mediation. You just have to do it before you file a lawsuit. That's what it says. That's what subsection E says. Now,
Well, it also says that the state engineer will arrange for a mutually agreeable mediator. That sounds like an administrative process to me. It's imposing a duty upon a state actor to facilitate this dispute resolution process. Why isn't that administrative?
I guess it's administrative in that sense, but I think then we need to look at this in terms of mandatory and permissive administrative remedies and how one exhausts those remedies.
So at the
under-
moment
under
they
Arizona
demanded
law.
mediation, it wasn't permissive for your client.
Well, certainly our
we can
client
agree
had
on that,
had to
right?
arrange the mediator, and
Well, yeah, I mean, your client had no choice. Your client couldn't say, "No, we're going to reject this demand for mediation. We're just not going to participate." That was not an option under the under the contract, right?
not on the face of the contract, correct.
Was it an option under any reading of the contract? That
To
your
reject the
participation
request and to not.
that your participation in mediation following the demand was in any way permissive. Can you get that from this contract? Because I can't.
No, but I don't think it should be looked at from the perspective of for whom it was mandatory or permissive, because, or that once they demanded, we had to do it. I think you could look at this under typical or well-settled exhaustion of administrative remedies law, and this is a permissive remedy, and that the right to sue, the accrual of the claim, actually occurred before that. It's not unlike the motion for rehearing that the court talked about in Southwestern Paint.
And that would be very persuasive had the legislature not taken pains to tell us that the rule is otherwise. In subsection C, the legislature, and the legislature doesn't do this much, right? The 12.82101 is a pretty harsh bar to litigation, and it's generally been applied quite literally. So if we're going to apply the statute literally, and the legislature takes pain to say, we're going to delay the accrual based on a process like this, that strikes me as a little bit more significant to our case than general notions of accrual and sort of what would happen without subsection C.
I think that there are a couple of things. One, under ordinary principles of exhaustion of administrative remedies, if those remedies are set forth in an ordinance or a rule or a statute or a contract, I think that the right to sue would necessarily, by operation of law, be deferred until those processes or that process have been exhausted, as defined under the relevant rule, statute, contract, et cetera. I think what the issue with subsection C that lends itself to standards reading, and I don't agree with that, is that subsection C consists of three sentences. One is a very long sentence and two shorter ones. The very long sentence starts off by naming or calling out three things: dispute resolution process, an administrative claims process, and a review process. And then what it does at the end of the sentence, it uses the less than artful phrase, all such, to refer back to the things that it mentioned at the beginning.
Well, but it also uses what seems to be a fairly artful list, then, of nouns to try to be as encompassing as possible. Procedures, processes, or remedies. Mediation seems to me to be at least a process.
Well, I think that those additional words are just different ways of talking about referring back to the three things that it started with. I don't think it adds anything to that.
No, but I think it's certainly suggests that mediation should not be excluded as a process. And the fact that there's a period at the end of a very long enumerated list of engineers who are going to review this claim doesn't seem to me to answer the question whether mediation is a process under the contract.
I would submit two things, Your Honor. First of all, what this court said in Andrus, I think, is relevant here. The court said that subsection C allows parties to exhaust any statutorily or contractually mandated pre-litigation, arbitration, or administrative remedies before resorting to the formal legal process.
Well, that's why you were there at the mediation, because you were mandated by a contract.
Right, but the remedy in the first instance was permissive, and that's the point.
And do you think that by its silence the legislature meant to create this very specific exception that says if you have a contract that makes it mandatory for one party but permissive for another party, it's not told, and you place your whole lawsuit at risk by seeking to resolve the dispute, which, by the way, is nominally the purpose of the notice of claim statute to begin with, all that is established by silence? That's a stretch.
No, but what the statute does do, Your Honor, it it defers to the sources of the duty to engage in the administrative process. And what I mean by that, it calls out these various ways in which that duty could arise: statute, a resolution, an administrative rule or regulation, or a contractual term. In any case in which this subsection is implicated, you've got to look at that source to find out what the process was. And in this case, the process was 3 steps that concluded with a final decision by the state engineer.
Well, why is that the process? Because right in that same part of the contract, there's another process. It just happens to begin with the letter E, but that's the subsection on ADR. Why isn't that part of the process?
Because the contract says otherwise. The
No, it
contract says
doesn't.
under subsection D that once that final decision is issued by the state engineer, that the contractor has a right to go forward with a lawsuit. And there's more, Your Honor, because it even calls out the statutes, 12A21 et sec means those that follow.
I'm
And
aware of that.
indeed, the next section is 12A2101. It's saying, in effect, once the state engineer issues its decision, contractor, go out and file your notice of claim and get started on your lawsuit if you don't want to accept the decision.
Well, it says you have a right to sue that has accrued. Most contracts don't say you have a right to sue because they don't have to. We know that in the case of breach, everybody has a right to sue. But this is telling you that once you've exhausted that process, now there are a couple ways this can go, right? You can go straight to court. Mr. Egbert might argue otherwise, that you have to do this mediation because some case says may mean must. But let's assume for a moment we set that aside. You can go straight to court, or you can demand ADR. And if you demand ADR, it's not that you've just gone out to some private mediator. You've demanded ADR, and the state engineer, the very person who was involved in the last stage of the administrative process, has to participate in this stage. So I don't know where you get, apart from punctuation, that the administrative process has just ended and now we're conducting some process that is non-administrative.
Well, it's not an administrative review. Certainly, here's where
Doesn't
standard
say review.
Here's where standard really gets
Statute doesn't say anything about review.
Here's where standard really gets this wrong, Your Honor. The mediation is not an opportunity for the state engineer to revisit his final decision and issue some other decision. That's not what this is about.
No, it's an opportunity for the state engineer potentially to waive some of the force of the decision in an effort to compromise, which didn't happen here.
I would analogize it to something else, Your Honor, and that is it's not unlike a situation where parties go to trial and the jury issues a verdict. If the parties decide to go to a mediation following a jury verdict, and that happens, of course, and decide to resolve their dispute, it doesn't change the verdict. The verdict is the verdict. The party's legal rights and obligations as established by the jury and the judgment that would follow from that does not change just because the parties agree to do something else.
Well, okay, so if we had a statute that said after a jury verdict, the court, one of 2 things may happen, well, one of 3 things may happen. The court may enter judgment and you may appeal. Right? The court may suspend entry of judgment, thereby preventing the appeal from becoming ripe while you pursue ADR. Or if one party demands ADR, then ADR will happen and the time to appeal is suspended until the conclusion of the ADR. If we had that, that would be a closer analogy.
It's just an analogy, Your Honor. I agree that it's not perfect. But there are other problems with standards argument under 12A2101C. If we're going to look at all the words and phrases of the statute and give them all meaning, then let's go ahead and look at what the next sentence says. It says that the claim accrues when a final decision or notice of disposition is issued. So again, final decision, that happened, of course, when the state engineer issued his final decision in June. And there was certainly no notice of disposition. If standard is right, and that's when its claim accrued at the end of the failed mediation, that's what it's arguing here, well then, under subsection C, the court would have to find some final decision or notice of disposition from which to trigger that accrual. And it just doesn't exist here. Standard doesn't allege it, and certainly there would be none in a mediation
Okay,
because,
I take your point.
Yeah.
There's a little tension between final disposition and conclusion of mediation, but what non-binding dispute resolution process did the legislature have in mind that wouldn't be akin to mediation? If it's non-binding, it essentially inherently doesn't involve the kind of judgment-like decisions that you would have in a binding process. Yet the legislature went out of its way to say non-binding counts.
that's true, but there are also situations like an arbitration that could be non-binding. In Superior Court, it's a bad example, I understand, because that happens after a lawsuit is filed. But in Superior Court, certainly the arbitrator issues a decision, that's not binding on the parties, they can appeal that. So there are situations in which
I could extend your time by 2 hours and we could talk about whether we should have that rule at all, but let's move past it.
Sure. So I think to sum up here, Your Honor, the mediation, the failed mediation, doesn't present any kind of clear signpost from which a party could start counting the 180 days like a final decision does. I mean, that's a more common sense reason to construe it in the way that we're advocating, is that the engineer's final decision is what triggered the accrual of the claim, because at least the parties know when the clock starts. With the failed mediation, there's no procedure in the contract for the mediator to say, okay, now we've reached the end of the administrative process, the parties didn't settle, here's a notice of that, the clock starts, go ahead and sue.
Yet there's no dispute on this record, as a matter of fact, when the mediation ended, right? We don't have one party saying it ended in September and the other say, oh, no, it ended way back in July. That's not happening. We all know when it ended.
Absolutely true, Your Honor, but subsection C requires that there be a final notice of disposition or a final decision from which to gauge when the 180 days
So in a
starts.
non-binding dispute resolution process, who should be issuing that final notice?
In this particular case, it just doesn't work because if as
So
standard.
the legislature wrote surplusage?
Not saying surplusage, I'm just saying that in this case, the way that standard is trying to interpret the contract by extending the administrative procedure beyond the 3 steps.
I get that that's your point,
It
but
becomes
answer
very
my
messy.
question. My question is, in a non-binding dispute resolution process, who is supposed to issue the notice that you claim is the linchpin of this statute?
I think that burden is on standard to answer that question, but
Well,
in a
I
case
can-
in which there was an
I
arbitration.
promise I'll ask standard, but right now I'd like you to answer it, because it's your theory.
Sure. It's my theory that nothing like that existed and couldn't exist because we're talking about mediation, which we believe is
So the
outside
legislature wrote
process.
surpluses. It wrote this thing that the non-binding dispute resolution process can delay accrual, but to accrue, you've got to have this final notice that nobody in a non-binding dispute resolution process can issue. So that part we just sort of read out because it doesn't work neatly. Is that your
I
theory?
think standard's reading it out, Your Honor, because it doesn't exist in this case.
Okay.
And with that, my time is just about up. I'd also like to mention that the delayed accrual provision does not exist vis-a-vis the statute of limitations. And for that reason, the trial court was certainly correct. The claim accrued when the state engineer issued his final decision. Standard did not file its lawsuit within that 1 year following that. Thank you.
Thank you, counsel.
I would be remiss if I didn't ask you to start with that question.
I was going to say, before you asked me the question, I would go ahead and offer an answer, but now you have, and I still will, that our position would be that it only makes sense that the burden, if the state wants to rely on the statute of limitations against us, that they have within their ability to say, we've done mediation, we've now concluded it, it was unsuccessful, it's over. Either that or it has to be the mediator that would say, okay, I tried my best to mediate this, but either way, it can happen. It's not theoretically impossible to have happen. The statute can be complied with. They're the ones that want to rely on the statute of limitations to tell us we're out of court. And so they can either ask the mediator to do it, they can issue it themselves, and then we all won't have any type of ambiguity as to when we're supposed to do it. It's unfair to us to have to try to figure out the contract and the statute together and figure out when are we supposed to do this. It's either it either has to be construed in our favor or it has to be ruled as ambiguous and then construed against them. Just a few real quick points in cleanup. Council relies on the three-step process that's outlined in the contract. There's nothing that says, there's no identification of when the third step ends. And so either the mediation is part of that third step, because it's still the state engineer that's supposed to engage in mediation, and so that can be part of the third step. Nothing in the contract prevents that interpretation. And even if it is something separate, it still doesn't answer your questions about, isn't that still part of the administrative process as a whole, even if it's not cubbyholed within the third or first or second step. Point number two, council resorts to this well-settled ordinary exhaustion of remedies principles. That has nothing to do with this case. We're not talking about common law exhaustion of remedies. We're talking about a statute that we're required to follow in terms of statute of limitations and the deferred accrual.
Do you want to address the limitations issue independent of the notice of claim issue?
Yeah, I would submit, Your Honor, that Section 821.01 addresses both. There is a provision that makes reference to the 821, the one-year statute of limitations. This section, I'm sorry, I'm not finding it right now, and I'm running out of my seconds, but there is language in here that makes reference to that. And so our position is that this concept of deferred accrual applies to both the 180 days for the notice of claim and the 1 year for the filing of the suit.
Okay.
Counsel says that the different words are just different ways of saying the same thing. That's not how we construe statutes. Every word, every phrase we're supposed to strive to give meaning to. And here we can. Here, what the legislature meant was it's broader than just the processes that we listed above. It's all the procedures, processes, and remedies. I'm out of time, and I would ask the court to overrule and reverse the trial court's dismissal.
Thank you, counsel. We certainly appreciate the briefing that was submitted in this matter and the lively discussion we had here at oral argument. I will take this under advisement and issue a written decision in due course. With that, court is adjourned.